The morning light filtered through the pine trees, casting long shadows across the meadow that had been in my family for 3 generations. My property stretched 20 acres from the old farmhouse my grandfather built to the creek that marked the eastern boundary. I inherited this land when my grandfather passed away 5 years ago. His final words to me were simple: protect what is yours. For years, I lived here in perfect harmony with the surrounding nature. Every morning, I would wake to birdsong instead of alarm clocks. Every evening, I would watch deer venture from the tree line to drink from the small pond near my garden. This place was more than property. It was sanctuary. It was legacy. It was home. The first hint of trouble came when construction vehicles began appearing on the adjacent property. I watched from my porch as they cleared acres of woodland, replacing natural beauty with neat rows of streets and foundations. A new housing development called Whispering Pines Estates was breaking ground. I did not mind progress, but I valued the buffer of trees between my grandfather's land and whatever suburban paradise they were constructing. One Tuesday morning, a black luxury SUV pulled into my gravel driveway. A woman emerged, her blonde hair pulled into a tight bun, pearls gleaming against her collared shirt, and a smile that did not quite reach her eyes. She introduced herself as Catherine Wilkins, president of the Whispering Pines Homeowners Association. "I wanted to personally welcome our new neighbor," she said, extending a manicured hand. "Your property is adjacent to our development, and we hope to establish a good relationship." I shook her hand but noticed how her gaze kept drifting past me to my modest house and the untamed land beyond. She called it unused potential. I called it exactly the way my grandfather wanted it. "Have you considered selling any of your acreage?" she asked casually. "Our community has received tremendous interest, and we are looking to expand our footprint. We could offer you a very competitive price." I declined politely, explaining the sentimental value of the property. Her smile tightened just slightly. "Well, if you change your mind, here is my card. We would love to help you capitalize on this rustic setting." 3 days later, I received an official letter from the county planning department. It referenced potential zoning changes affecting properties in my area, including mine. The language was vague, filled with bureaucratic terminology that seemed designed to confuse rather than clarify. I filed it away, making a mental note to look into it further. The following week, I returned home from grocery shopping to find survey stakes with bright orange flags planted 20 feet inside what I knew to be my property line. A construction crew was measuring and marking the area. When I confronted them, their foreman showed me a site plan that included a portion of my land. "Just following the development plans, sir," he said, not bothering to remove his hard hat. "You will need to take this up with the HOA if you have concerns." That evening, as the sun set behind the trees my grandfather had planted, I noticed Catherine, or Karen, as I had begun thinking of her, walking the newly staked area with a contractor. When she saw me watching, she waved cheerfully as if nothing was amiss. I went to my attic that night and pulled out the old metal lockbox where my grandfather kept all his important documents. The deed to the property was there, along with hand-drawn maps and the original land survey from when he purchased it in 1962. The boundaries were clear: the creek to the east, the old hickory tree line to the south, the county road to the west, and the stone markers my grandfather had placed himself to the north. I spread the documents across my kitchen table, comparing them to the current county maps. Something was wrong. According to the new plans, almost 3 acres of my northern boundary had been incorporated into the Whispering Pines development zone. I was not imagining things. I was not confused. Karen and her HOA were making a play for my land, and they thought I was too simple to notice. The invasion began with trees. My grandfather had planted a line of red maples along the northern edge of our property as a natural boundary. One morning, I woke to the sound of chainsaws. By the time I reached the property line, 3 of the maples had already fallen. Construction workers in hard hats moved methodically down the line, clearing what they claimed was development land. I marched up to the closest worker, demanding to see their permits. He barely looked up from his chainsaw before jerking his thumb toward a portable trailer stationed at the edge of the worksite. Inside, I found a thin man with wire-rimmed glasses studying blueprints. "Those trees are on my property," I stated flatly. "You have no right to cut them down." He sighed, clearly annoyed by the interruption, and pulled out a thick folder of permits. "We have approval for the entire development zone," he said, pointing to a highlighted section. "Phase 2 includes this section all the way to the creek." "The creek is my eastern boundary," I corrected him. "You are currently on my northern boundary, and those trees are at least 20 feet inside my property line." The site manager shrugged. "The plans say different. Look, we are just following orders. If you have an issue, you need to take it up with the HOA board. I just manage the construction." That afternoon, I called the county planning office, only to be transferred between 3 different departments. Each official sounded more bored than the last, eventually telling me I would need to file a formal complaint. One helpful clerk mentioned that the development plans had indeed been updated quite recently through a rezoning agreement. When I asked who had signed off on this rezoning that included my land, she hesitated. "It looks like it was approved by Catherine Wilkins, representing the interests of adjacent property owners." The next day, I received a neatly printed invitation to attend a Whispering Pines HOA meeting to discuss property integration concerns. The meeting was scheduled for that evening at 7. I arrived 10 minutes early, only to discover they had started at 6:30. Karen sat at the head of a conference table, surrounded by well-dressed board members and several homeowners. "Ah, here he is now," she announced with false warmth. "We were just discussing the northern expansion project and your concerns." For the next hour, I listened as Corinne presented her version of events. According to her, my property line had been officially updated through proper channels. She used terms like community interest and development rights, while characterizing my position as non-compliant and resistant to progress. "The truth is," she told the attentive board members, "some people simply do not understand how property development works in growing communities. Change can be difficult for those who cling to outdated notions." When I attempted to present my deed and survey documents, Corinne smoothly cut me off. "We have all the current official documentation on file. Your personal papers, while charming, do not supersede county-approved plans." The following week, concrete foundations were poured for what Corinne called luxury rental units on the cleared section of my land. When I physically blocked a bulldozer from extending the work further into my property, she had security escort me away. Later that day, I received a certified letter threatening legal action for obstructing approved development activities. That was the moment I realized this was not a misunderstanding. It was a calculated land grab. Corinne had somehow manipulated the system, counting on my rural simplicity and lack of connections to get away with it. She had picked the wrong target. I drove an hour to the city and met with Lawrence Hoffman, a land rights attorney with 30 years of experience. I brought all my documentation, the original deed, my grandfather's surveys, photographs of the property before and after the construction began, and the threatening letter from the HOA. Lawrence studied the documents carefully, his expression growing more serious with each page he turned. "This is not right," he finally said. "They are banking on you giving up, but we are not going to let that happen. I am going to request a full title search on both parcels and file for an emergency land survey." As I left his office, my phone buzzed with a text message from my neighbor. "They are breaking ground on the next section tomorrow morning, bringing in more equipment." Karen was speeding up her plans, but what she did not know was that I was about to change the game entirely. Lawrence worked faster than I expected. Within 3 days, he had uncovered the first piece of evidence that would unravel Karen's elaborate scheme. The rezoning document submitted to the county planning office contained a signature that was supposedly mine, authorizing the boundary adjustment. The signature was a forgery, not even a good one. "This is a serious offense," Lawrence explained, spreading the documents across his desk. "Forgery of property documents is a felony in this state, but there is more." He showed me the original land deed from my grandfather. The boundaries were marked not just by descriptions, but by permanent markers, stone cairns that had stood for decades. According to the legal description, my property extended a full quarter-mile beyond where Karen had started building. "How did they get this past the planning office?" I asked. Lawrence's expression darkened. "I made some inquiries. It seems Catherine Wilkins has a very close friend in the planning department, James Horvath, Deputy Director of Zoning. The permit approvals were all signed by him, some backdated by several months." I leaned back in my chair, the pieces falling into place. So she used her connection to push through fake documents. Exactly. And she is moving quickly because she knows it will not stand up to scrutiny. My contact at the county records office says the HOA has applied for financing based on projections for 100 rental units. She is planning to build them, sell them to investors, and disappear with the profits before anyone realizes what happened. That afternoon, Lawrence filed a formal land dispute and injunction request with the county court. The judge scheduled a preliminary hearing for the following week. In the meantime, construction continued at a frantic pace. The workers were now operating around the clock, floodlights illuminating the site throughout the night. Karen's response to our legal action was swift and petty. The morning after we filed the injunction, I woke to find my entire property line festooned with bright orange, "No trespassing" signs. "Property of Whispering Pines HOA," they declared in bold black letters. She had placed them every 10 feet, even along sections where construction had not yet begun. I called Lawrence immediately. "She is marking my entire property as hers now." "Document everything," he advised. "Take photographs, videos, note the time and date. We need to establish a pattern of deliberate action." I purchased a drone that afternoon and began systematic documentation of the entire property. From above, the encroachment was even more obvious. The development had already consumed nearly 2 acres of my land, with foundations laid for multiple buildings. The aerial footage showed how the construction deliberately followed the forged boundary lines, ignoring the original markers. While reviewing the footage that evening, I noticed something interesting. The buildings under construction were not single-family homes like the rest of the development. They were multi-unit structures, apartment buildings designed to house far more people than the HOA had publicly announced. I did some research online and discovered that Karen had recently formed a separate LLC called Wilkins Property Management. According to business filings, this company was positioned to manage rental properties in the area. The picture became clearer. She was not just stealing my land for the HOA. She was setting herself up to personally profit from the rental income for years to come. The next day, I received a call from Lawrence. "I have more information," he said, his voice tight with controlled anger. "The documents Karen submitted to the bank for financing include projected revenue from 100 rental units, apartments that would be managed by her own company. She is estimating profits of over $2 million in the first 3 years alone." "Built on stolen land," I said quietly. "Exactly. And here is the thing. She needs to complete construction quickly because the financing terms require occupancy within 6 months. If she misses that deadline, the whole house of cards collapses." I watched through my kitchen window as another concrete truck rumbled onto my property. Karen was getting desperate, but her desperation was about to become her downfall. The legal process moved slowly compared to Karen's construction schedule. Even with the injunction filed, the buildings continued to rise on my property. Each day brought new workers, new materials, new structures. Karen had apparently decided that it was better to beg forgiveness than ask permission. If she could complete the apartments before the court ruled, she might argue that demolishing them would cause undue economic hardship. I documented everything meticulously, but it did not seem to matter. The bulldozers kept rolling, the hammers kept swinging, and Karen kept smiling that smug smile whenever our paths crossed. Then came the character assassination. Flyers appeared in neighbors' mailboxes describing me as an unstable individual who was obstructing community progress due to personal delusions about property rights. The letter, ostensibly from the HOA Board of Directors, urged residents to avoid interacting with me and to report any concerning behavior to Catherine Wilkins directly. My phone began ringing with calls from concerned neighbors who had known my family for years. Most did not believe the accusations, but the damage was being done. I was being painted as the villain in Karen's carefully crafted narrative. The harassment escalated. One morning, I discovered my truck tires slashed. The following night, eggs pelted my house, leaving yellow stains on the white siding my grandfather had installed himself. My mailbox was knocked over and garbage was strewn across my front yard. Each incident seemed designed to push me toward retaliation, to make me act in ways that would validate Karen's claims about my mental state. I refused to take the bait. Instead, I installed motion-activated cameras around my property, high-quality ones that could record clearly even at night. I placed them strategically, covering every approach to my house and the disputed property line. It took only 3 days to catch them in the act. The night footage showed 3 men, all wearing Whispering Pines HOA shirts, crossing onto my property at 2:17 a.m. One carried a can of spray paint which he used to deface my tractor with the word "loser." Another placed a broken garden gnome on my porch, a bizarre touch that made their intentions clear. This was not random vandalism. This was intimidation. I took the footage to the local police station the next morning. The desk sergeant reviewed it with obvious discomfort. "I see what you are showing me," he said carefully, "but identification is difficult in night footage. These could be anyone." "They are wearing HOA shirts," I pointed out, with the Whispering Pines logo clearly visible. He shifted uncomfortably. "Anyone could get those shirts. Look, we will file a report but without clearer identification." I left the station feeling frustrated but not surprised. Later, I learned that Sheriff Williams was a golf buddy of Catherine's husband. The system that should have protected me was compromised at every level. Lawrence advised me to prepare a civil suit encompassing all the harassment and vandalism, linking it directly to the land dispute. "We need to show a pattern of behavior," he explained. This is not just about property lines anymore. This is about systematic intimidation and fraud. He also suggested contacting local media. Public scrutiny is powerful. If we can get a reporter interested in this story, Catherine's house of cards might start to wobble. I was hesitant at first. I had always been a private person, like my grandfather before me. But I realized that privacy was a luxury I could no longer afford. This battle had become public the moment Corinne decided to target my land. The final straw came when I overheard Corinne at the local coffee shop, speaking loudly on her phone about the expansion problems. I had stopped in for a simple cup of coffee, but found myself frozen in place as her voice carried across the small space. "We simply need to finish Phase 3 before that injunction hearing," she was saying. "Once the units are built, no judge is going to order them torn down. The economic impact argument will overrule any property dispute." I had my phone out, recording, before I even realized what I was doing. What she said next would become the centerpiece of our case. "Of course I know it is technically his land," she continued, laughing. "But possession is 9/10 of the law. By the time the court rules, we will have possessed it quite thoroughly." The recording was crystal clear. Corinne had just admitted on tape that she knew she was building on my property. The legal trap was set. Now it was time to spring it. The injunction hearing arrived on a rainy Tuesday morning. The county courthouse was an imposing structure of red brick and white columns, built in the same era as my grandfather's house. Lawrence and I arrived early, armed with documentation, photographs, and the damning audio recording. Judge Patricia Harmon presided, a stern woman with silver hair and reading glasses that hung from a chain around her neck. Corinne arrived with two attorneys in expensive suits, exuding confidence as she took her seat at the respondent's table. Lawrence presented our case methodically, showing the original deed, the survey markers, and the aerial photographs documenting the encroachment. He submitted evidence of the forged signature and the suspicious timing of the rezoning approvals. The judge listened attentively, asking occasional questions but giving little indication of her thoughts. Then came the recording. As Corinne's voice filled the courtroom, "Of course I know it is technically his land." Her expression shifted from confidence to shock. Her attorneys leaned in, whispering urgently, but the damage was done. Judge Harmon's decision was swift and unequivocal. The court grants the injunction. All construction on the disputed property must cease immediately pending full resolution of the ownership claim. Corinne's attorney immediately objected, arguing that stopping construction would cause irreparable financial harm to the development. The judge was unmoved. "The potential harm to the rightful property owner outweighs any financial concerns of the developers," she stated firmly. Furthermore, the court finds sufficient evidence of possible fraud to warrant a full investigation. The injunction stands, effective immediately. Outside the courthouse, Corinne cornered me in the parking lot. "This is just a temporary setback," she hissed. "A technicality. The development will continue." True to her word, the construction did not stop. If anything, it accelerated. The day after the injunction was issued, twice as many workers appeared on the site. The message was clear. Corinne was gambling that she could complete the buildings before any further legal actions could stop her. Lawrence was furious when I sent him photographs of the ongoing construction. "She is in contempt of court," he said. "This is flagrant disregard for a legal order." While Lawrence prepared an emergency motion for contempt charges, I made a decision. I contacted Sarah Jimenez, an investigative reporter for the local news station, who had recently covered stories about development controversies in neighboring counties. "I have documentation of an HOA building on private property after being ordered by a court to stop," I told her, including audio of the HOA president admitting she knows the land is not hers. Sarah was at my property the next morning with a cameraman. We walked the disputed boundary line, camera rolling as I explained the situation. I showed her the original deed, the survey markers, and footage of the construction continuing despite the court order. The story aired that evening on the 6 o'clock news. HOA builds on stolen land. Homeowner fights back. The segment included aerial drone footage of the construction, images of the original property documents, and most devastatingly, the audio of Karen's coffee shop admission. By morning, the story had gone viral on local social media. Residents of Whispering Pines began calling the HOA office demanding explanations. Several who had purchased homes in the development expressed concerns about the legality of their own properties. The county planning office, suddenly under public scrutiny, announced an internal investigation into the rezoning process. James Horvath, Karen's friend in the planning department, was placed on administrative leave pending review of his approvals. The construction equipment fell silent for the first time in weeks. Workers were told to stand down until further notice. Karen stopped answering her phone. Lawrence called with more news. "The judge has granted our emergency motion. Catherine Wilkins has been ordered to appear for a contempt hearing tomorrow morning. And there is more. The county prosecutor's office is reviewing the evidence for possible criminal charges related to the forgery." The tide had turned. The trap had been sprung, and Karen was caught in it. Her assumption that she could bulldoze her way through proper legal channels had backfired spectacularly. What she had not counted on was my patience, my documentation, and my unwillingness to be intimidated. As I stood on my porch that evening, watching the sunset over land that had been in my family for generations, I felt a profound sense of vindication. The battle was not over, but for the first time, I knew with certainty that I would win. The county courthouse was packed to capacity for the special hearing. News cameras lined the back wall, and every seat in the gallery was filled. Karen entered flanked by her attorneys, her usual confidence noticeably diminished. She wore a conservative navy suit and had toned down her makeup and jewelry, an obvious attempt to appear more serious and sympathetic. Judge Harmon called the session to order with a sharp rap of her gavel. "This hearing will address multiple issues regarding the Whispering Pines development and the adjacent property dispute. We will hear testimony from all relevant parties." The county prosecutor, Andrew Diaz, presented first, outlining the irregularities in the rezoning process. "Your Honor, our preliminary investigation has uncovered numerous discrepancies in the documentation submitted by Ms. Wilkins and the Whispering Pines HOA. Most troubling is the apparent forgery of the property owner's signature on multiple documents." James Horvath, the planning official who had approved the falsified documents, was called to testify. Visibly nervous, he initially attempted to defend his actions as standard procedure. Under cross-examination, however, he crumbled. "Ms. Wilkins assured me that the property owner had verbally agreed to the boundary adjustments," he admitted. "She said the paperwork was just a formality that he would sign later." "Did you personally verify this with the property owner?" Lawrence asked. Horvath stared at his hands. "No." "Did you compare the signature on the documents with specimens on file?" "No." "Did you receive any personal benefit from expediting these approvals?" Horvath's face flushed. "I, Ms. Wilkins offered me first choice of the rental units at a significantly reduced rate. By lunchtime, Horvath had resigned his position rather than face further questioning. The hearing reconvened with testimony from current Whispering Pines residents. Margaret Chen, a retired schoolteacher who had purchased one of the first homes in the development, described how the HOA under Karen's leadership had become increasingly controlling and punitive. We were told we were buying into an exclusive community with reasonable guidelines. Instead, we got an authoritarian regime that issues fines for grass being half an inch too tall. Thomas Acaffer, another homeowner, detailed how Karen had selectively enforced HOA rules against residents she disliked, while ignoring violations by her friends. She fined me $300 for planting unauthorized flowers in my garden. Meanwhile, her friend Brenda built an entire gazebo without approval and faced no consequences. One by one, residents shared their experiences. A pattern emerged of intimidation, favoritism, and financial mismanagement. The HOA fees had increased 3 times in 2 years, with little explanation of where the money was going. Then it was my turn. I described how my family had owned the land for generations, how Karen had approached me about selling, and how construction had begun on my property without my knowledge or consent. I presented the timeline of events, supported by photographs, documents, and the recordings. "And did Ms. Wilkins ever acknowledge that she knew the land belonged to you?" Diaz asked. "Yes," I replied, and played the coffee shop recording once more for the court. Karen took the stand last, her attorneys having advised her to appear cooperative. She attempted to portray herself as a misunderstood community leader who had simply made administrative errors. There was confusion about the property lines, she claimed. The county records were unclear. "Ms. Wilkins," Judge Harmon interrupted, "are you suggesting that the original deed, the survey markers, and your own recorded admission are all examples of confusion?" Karen faltered. "I may have misspoken in that recording. It was taken out of context." "The context seems quite clear," the judge replied. "You stated explicitly that you knew the land belonged to someone else." By the end of the day, Judge Harmon had heard enough. Her ruling was comprehensive and devastating for Karen and the HOA. This court finds that Catherine Wilkins and the Whispering Pines Homeowners Association knowingly and willfully encroached upon private property, despite clear evidence of ownership by another party. Furthermore, they continued this encroachment after receiving a direct court order to cease construction. The judge ordered an immediate and permanent halt to all construction on the disputed land. She invalidated all rezoning documents related to my property and ordered a new, independent survey to officially reestablish the original boundaries. The HOA was prohibited from making any further claims on any portion of my land. Additionally, Judge Harmon continued, this court removes Catherine Wilkins from her position as HOA president, effective immediately, and refers the matter of document forgery to the district attorney's office for potential criminal charges. As the gavel fell, Karen's carefully constructed world collapsed around her. The power she had wielded so carelessly had been stripped away in a single afternoon. The public reckoning she had feared had finally arrived. The aftermath of the hearing unfolded rapidly. Karen was removed from the HOA board and replaced by a temporary management committee. The district attorney's office opened a formal investigation into the document forgery, which carried potential felony charges. James Horvath agreed to testify against Karen in exchange for leniency in his own case. 3 days after the hearing, I received a call from one of Karen's attorneys. Ms. Wilkins would like to offer a settlement, he began cautiously. She is prepared to compensate you for any inconvenience caused by this unfortunate misunderstanding. Misunderstanding, I repeated, the word tasting bitter on my tongue. A generous settlement could resolve this matter quickly and privately, he continued. Ms. Wilkins is prepared to offer $200,000 in exchange for dropping all claims and allowing the completed structures to remain. I did not hesitate. No. Perhaps you should take some time to consider. This was never about money, I interrupted. This is about justice. This is about respect for property rights and the rule of law. This is about my grandfather's legacy. The civil case proceeded to trial. The evidence was overwhelming, and the jury deliberated for less than 3 hours before returning a verdict in my favor. They awarded me damages for trespassing, property destruction, emotional distress, and legal fees. The total came to just over $1 million. More importantly, the court ordered the demolition of all structures built on my property. Karen and the HOA were responsible for returning the land to its original condition, including removal of foundations, replanting of trees, and restoration of the natural landscape. I watched from my porch as the demolition crews took down the half-finished apartment buildings. The same machines that had once torn into my land now dismantled the fruits of Karen's deception. There was a certain poetry to it, justice manifesting in concrete and steel being reduced to rubble. Karen sold her home in Whispering Pines at a substantial loss and moved away from the area. Rumors circulated that she had relocated to another state, presumably to escape the cloud of scandal that now followed her name. The last I heard, she was facing criminal charges for the forgery and had been named in multiple civil suits from Whispering Pines homeowners who felt defrauded by her mismanagement. I used a portion of the settlement money to reforest the damaged section of my property. Working with a local conservation group, I planted native trees and shrubs to replace those that had been cleared. I installed wildlife cameras throughout the area, capturing the gradual return of deer, foxes, and countless birds to their restored habitat. The remainder of the settlement went into a trust dedicated to preserving family farms and homesteads facing development pressure. I named it after my grandfather, ensuring that his legacy would continue to protect others from the same kind of predatory tactics that Karen had employed. 6 months after the demolition was complete and the first new saplings had taken root, I invited neighbors from both my rural community and Whispering Pines to a small gathering on my property. We gathered around a bonfire near the restored northern boundary, sharing food, stories, and a renewed sense of community. Margaret Chen, the retired teacher who had testified about Karen's HOA abuses, approached me with a glass of lemonade. "You know," she said thoughtfully, "some good came from all this. The HOA is actually functional now. People talk to each other instead of filing complaints. We are becoming a real neighborhood." Thomas Ockhaffer nodded in agreement. Sometimes you need to see the worst of something to appreciate the best of it. Karen showed us how not to be neighbors. As the sun set over the property that had been in my family for generations, I felt my grandfather's presence. I had honored his final words, "Protect what is yours." But I had done more than that. I had stood against corruption and bullying. I had reminded an entire community that justice, while sometimes slow, is still possible. In the end, Karen's ambition had been her downfall. She had seen my land as nothing more than square footage to be exploited. She had seen me as a simple country resident who could be intimidated or outmaneuvered. She had miscalculated on both counts. The truth is, there are some things money cannot buy. There are some people who cannot be bullied. There are some principles worth fighting for, no matter the cost. My grandfather understood this. Now, thanks to Karen's ill-fated land grab, so did everyone else in our community. As the fire crackled and conversation flowed around me, I looked out at the new trees standing tall against the darkening sky. They would grow stronger each year, their roots reaching deep into soil that had been protected by principle and perseverance. Just like the truth, they had prevailed.